"You don't belong in this building," the woman said, her voice carrying across the entire lobby of the Hargrove Federal Courthouse, loud enough that the security guards looked up, loud enough that the attorneys in their pressed suits turned their heads, loud enough that Dominique Reese, standing perfectly still with her visitor badge clipped to her lapel and her briefcase in her right hand, felt the words land like a physical thing against her chest. The woman who said it was Courthouse Administrator Patricia Ellen Witt, 62 years old, 28 years behind that front desk, and absolutely certain. The way some people are certain about things they have never once examined, that the tall black woman in the charcoal blazer had wandered in from somewhere she had no business being. Dominique said nothing. She set her briefcase down slowly, reached into the front pocket and pulled out her ID. Not the visitor badge, the other one. She held it up at eye level and waited. Witt squinted at it, then squinted harder. Then the color drained out of her face so completely and so fast that the security guard 2 feet away her, thinking she was about to faint, because the ID said, Dominique A. Rees, Inspector General, United States Department of Justice. And Patricia Ellen Witt had just publicly humiliated the woman who had spent the last 9 months building a federal case against the very courthouse she ran. What Witt did not know, what almost no one in the Northern District of Georgia knew, was that the routine audit notice the courthouse had received 6 weeks earlier was not routine. It never had been. The audit was a door held deliberately ajar, and Dominique Reese had been standing quietly on the other side of it, waiting for the people inside to do exactly what corrupt people always do when they think they are unobserved: get comfortable. The Hargrove Federal Courthouse in Atlanta had a reputation. Publicly, it was the model of efficiency, a well-funded, high-profile district court with a newly renovated atrium, a landmark racial equity mural painted across the third-floor rotunda, and a presiding chief judge who gave keynote speeches at legal conferences about access to justice for underserved communities. His name was Judge Calvin Mercer, and he was, by every visible metric, exactly the kind of figure the legal establishment liked to celebrate. Privately, the courthouse was something else entirely. The DOJ's Public Integrity Section had received its first credible tip 14 months ago from a paralegal who had quietly resigned after witnessing what she described as systematic case steering. Defense attorneys with established relationships with certain clerks were receiving advance notice of case assignments, not the judges themselves, but the assignment pool. A phone call here, a favor there, and suddenly a defendant with the right amount of money retained an attorney who already knew which judge would be presiding, which meant they could calibrate their arguments, their jury consultant choices, their entire defensive posture before the prosecution had finished its morning coffee. It was elegant, in the way that carefully engineered corruption always is. No money changed hands in ways that were immediately traceable. It ran on access and reciprocity, and the unspoken ledger that powerful people keep between themselves. And it had been running, by the DOJ's estimate, for nearly 6 years. Dominique had been assigned to lead the investigation 8 months before she ever set foot in Atlanta. She had read every file, mapped every relationship, traced every anomalous outcome in the district's civil rights and housing discrimination docket. The cases that kept getting delayed, reassigned, quietly settled for pennies on the dollar when the defendants had money, and the plaintiffs did not. She had built the case the way she built all her cases, slowly, precisely, without ego, without the need to announce herself. Her cover was simple and, critically, completely true. She was an auditor from the DOJ's Administrative Oversight Division. She was there to review court records management, filing protocols, and budget compliance. It was exactly the kind of visit that made courthouse administrators nervous in a low-level, procedural way. The kind of nervousness that caused people to straighten supply closets and update their filing indexes, not the kind that caused them to shred documents. That was by design. Dominique had spent her first 3 weeks doing nothing that wasn't on her stated audit checklist. She reviewed filing systems. She sat through administrative meetings. She ate lunch alone in the courthouse cafeteria, reading case dockets on her laptop with the mild distracted affect of a bureaucrat who found federal procurement codes more interesting than the people around her. She was polite to everyone. She learned names. She listened. She was invisible in exactly the way she needed to be. The first signal had come on a Thursday afternoon in the form of a courier delivery. Dominique had been in the records room on the second floor when she noticed a paralegal. Young, nervous, moving with the specific hurriedness of someone who had been told to be quick and not be seen, deliver a manila envelope to the senior clerk's office. Nothing extraordinary. Courthouses ran on paper, but the envelope was not logged. She watched the clerk, a man named Fitch, who had worked the assignment desk for 11 years, slip it into his desk drawer without opening it, without signing for it, without noting it in the intake log sitting open on his desk. She finished her review of the procurement records in front of her and said nothing. Over the next 2 weeks, she documented 4 more similar deliveries, different paralegals, same clerk, same desk drawer, same absence from any log. She had the courier company subpoenaed under a sealed order before she ever asked Fitch a single question. The couriers had been paid in cash, routed through a shell account registered to a legal staffing agency that, 3 corporate layers deep, traced back to a private investment partnership with 3 named members, one of whom was a senior partner at the most prominent criminal defense firm in Atlanta's Buckhead neighborhood. When Dominique found that, she called her supervisor in Washington and told him they needed to move the timeline up. He asked if she was sure. She said she was always sure before she made that call. The second signal had come from the docket itself. Dominique had written a custom query against 11 years of Northern District civil rights filings and cross-referenced assignment outcomes against attorney of record. The pattern was not subtle once you knew to look for it. Cases with plaintiffs represented by smaller firms, solo practitioners, public interest non-profits, underfunded legal aid organizations, were being assigned at statistically anomalous rates to judges with documented records of procedural dismissals on technical grounds. Not dismissals based on the merits. Dismissals based on paperwork. Filing deadlines missed by hours, not days. Jurisdictional objections sustained on arguments that were legally thin enough that 3 separate appellate opinions had questioned their validity. The plaintiffs in those cases were almost uniformly the same. Black and Latino renters fighting housing discrimination, wage theft claimants who had worked for large hospitality companies, elderly residents of a southwest Atlanta neighborhood fighting a zoning reclassification that would have demolished 340 homes to build a distribution facility. The distribution facility had been built. The homes were gone. Dominique had looked at that data for a long time. She had a specific method for managing what she felt when she looked at data like that. She named it. She sat with it for exactly as long as it needed, and then she folded it down into something small and cold and very precise that lived behind her sternum and made her better at her job. She went back to auditing procurement records. She had been in Atlanta for 9 weeks when Patricia Ellen Ost Witt decided that Dominique Reese did not look like someone who belonged in the building. It was a Monday. Dominique had arrived at 8:15, signed in at the front desk the way she had done every morning for 9 weeks, clipped on her visitor badge, and was heading toward the elevator when Witt, in front of 3 attorneys, 2 clerks, and a security guard, called out across the marble lobby in a voice calibrated precisely for maximum social correction. "Excuse me, are you here for the public access terminal? Visitors without appointments need to check in at the side window." Dominique had never used the public access terminal. She had a dedicated workstation on the second floor with her name on a laminated card beside the door. She had an appointment with the chief administrator every Tuesday at 10. She had been in this building almost every working day for more than 2 months. She turned around. Witt was already moving toward her with the proprietary authority of a woman who had spent nearly 3 decades deciding who deserved to be where. "I'm going to need to see some identification," Witt said. "We've had some issues with unauthorized individuals accessing restricted areas." She glanced sideways at the security guard as she said it, a small recruitment move, pulling him into the performance of her certainty. The lobby had gone quiet. Dominique reached into her briefcase. She had 2 forms of identification with her. She chose the one she chose for a specific reason, because she had been waiting with great patience for a moment exactly like this one, in a public space, with witnesses. She held up the Inspector General badge and said nothing. She let Witt read it. She let the room read it. She watched the realization move across Witt's face, the way a weather system moves across open water. First a strange stillness, then the understanding that something had already changed and there was no going back to before it changed. I have a 10 o'clock with Chief Administrator Holloway, Dominique said, her voice even and unhurried. I know where the elevator is. Thank you. She picked up her briefcase and walked toward it. Behind her, no one said anything for a long moment. The meeting with Holloway that morning was the last meeting Dominique conducted under her audit cover. She had spent the previous weekend in her hotel room outside Atlanta with her second-in-command, a DOJ senior investigator named Agent Cora Pemberton, running through the operational sequence one final time. By Sunday evening, the federal warrants had been reviewed by the U.S. Attorney's Office for the Northern District, signed by a federal magistrate in D.C., who had no jurisdictional connection to the Atlanta courthouse, and sealed. The tactical coordination with the FBI's Atlanta field office was locked. The forensic IT team was staged. The bank holds on 3 financial accounts tied to the defense firm partnership had already been authorized. All that remained was the meeting. Holloway was a careful man, 60 years old, grey at the temples, the practiced geniality of someone who had spent a career reading rooms and adjusting himself accordingly. He had been cooperative throughout the audit in the specific way that people who have something to hide are cooperative, responsive, helpful, never volunteering more than was asked, always slightly too casual about the things that mattered most. He greeted Dominique with the same affable handshake he had offered every Tuesday for 9 weeks. He poured coffee. He asked how the records review was going. It's going very well, Dominique said. I've completed the administrative portion. I wanted to let you know that today we'll be transitioning to the second phase. Holloway set down his coffee cup. Something in his expression shifted, barely. Just a tightening around the eyes. Second phase? The integrity review, Dominique said. She opened her briefcase and set a document on his desk. Under Title 28, Section 594 of the Inspector General Act, the OIG has expanded jurisdiction to review case assignment practices and communications records when preliminary audit findings indicate potential systemic irregularities. She let him read the first paragraph. We'll need access to the clerk assignment logs going back 6 years, all internal communications on the courthouse network for that period, and the personnel files for the assignment desk staff. Holloway was quiet for a moment, then, I'll need to loop in our general counsel. Of course, Dominique said. You can reach him at the number on page 3. He's been briefed. She paused. The U.S. attorney has also been briefed. She's on the same page. He looked at her then, really looked at her the way people look when they are trying to determine exactly how much the person across from them already knows. Dominique held his gaze and said nothing. I see, Holloway said finally. I imagine you do, she said. What happened next unfolded the way Dominique had planned it, with the exception of one variable she had not predicted and had come to quietly appreciate. Judge Calvin Mercer came to find her. She had been in the second-floor records room with Pemberton and 2 forensic analysts when she heard the knock. Mercer was in his robes. He had apparently come straight from the bench during a recess, and he closed the door behind him with the specific energy of a man who had decided that confrontation was preferable to uncertainty. He was 64 years old, tall, and had spent his career cultivating the kind of gravitas that made people in courtrooms feel the weight of his presence. Before he said a single word, he walked to the center of the room and looked at Dominique with an expression she had seen before. The look of someone powerful who has not yet accepted that they are not, in this moment, the most powerful person in the room. I'd like to understand, he said carefully, the scope of what's happening here. Judge Mercer, Dominique said, and the simple directness of his name without a title, without a Your Honor, was deliberate and precise. My name is Dominique Reese. I'm the Inspector General for the DOJ's Public Integrity Division. We've been conducting a federal investigation of case assignment irregularities in this district for the past 9 months. I'm not able to discuss the details with you at this time, as you are a subject of that investigation. The word subject landed in the room like something solid. Mercer's composure did not break. He was too experienced for that. But she saw the adjustment, the recalibration, the moment when a man who had walked into a room expecting to take control of a situation understood that the situation was not available to be taken. I'd like to contact my attorney, he said. You are absolutely entitled to do that, Dominique said. I'd suggest sooner rather than later. She turned back to the forensic analyst beside her and resumed the conversation she'd been having before the knock. Mercer stood in the room for another moment. Then he left. Pemberton looked at Dominique. "How long have you been waiting to do that?" 9 months, Dominique said, "give or take." The formal arrests happened 3 days later. Dominique had advocated for the timing specifically, not the same day as the confrontation with Mercer. That would have been reactive, and reactive was not how she worked. She wanted 3 days. Long enough for the network to begin to feel the vibration of what was coming. Short enough that they could not coordinate a meaningful response. She had watched enough corruption cases collapse at the final stage because investigators moved too fast, before the web was fully documented, or too slow, giving the principals time to destroy evidence and flip the narrative. 3 days was the window, at 7:45 on a Thursday morning. Deliberately chosen, because Mercer held his weekly judicial staff meeting at 8 and the entire courthouse administrative leadership would be assembled in one room. 12 federal agents from the Atlanta field office entered the Hargrove federal courthouse through separate entrances simultaneously. Dominique was already inside. She had arrived at 7:15, gone through security, nodded to the guard who knew her by name now, and taken the elevator to the second floor. She stood in the hallway outside the conference room, where Mercer's staff meeting would begin in 15 minutes, and waited. Pemberton came through the stairwell door at 7:49, 4 agents behind her, and gave Dominique a single nod. The conference room door opened at exactly 8 o'clock. Mercer's assistant stepped out, saw the agents in the hallway, and froze. "It's all right," Dominique said to her. "Please step to the side." She walked into the conference room. Every person at the table looked up. Mercer was at the head, mid-sentence, coffee cup in hand. Holloway was to his left. The senior clerk, Fitch, was 2 seats down. 6 other administrative and judicial staff filled the remaining chairs. The room went completely still. Dominique set a bound copy of the federal indictment on the table in front of Mercer. Then she looked at him and said, with the same even cadence she had used for every single word in this building for 9 months, "Judge Mercer, you are under arrest for conspiracy to commit wire fraud, obstruction of justice, and violation of the Racketeer Influenced and Corrupt Organizations Act. You have the right to remain silent." Mercer looked at the indictment. He looked at Dominique. He looked at the agents behind her. And then he looked back at Dominique, and she saw it. The thing she had been waiting for, the specific reckoning that came to powerful people, in the moment they finally understood that they had miscalculated not just the situation, but its geometry entirely. "You were auditing us," he said. "Not a question. I was investigating you," Dominique said. "The audit was the door." She read him his Miranda rights herself. She had requested that specifically. She could have let Pemberton do it. That was standard, but she had requested it, and her supervisor had not asked why. Because he had worked with her long enough to understand that Dominique Reese did not make requests without reasons. The reason was this. The last time she had stood in a federal courthouse in Atlanta, she had been 23 years old, and she had been there because her uncle, a man named Arthur, who had worked his entire adult life as a licensed electrician, had been the subject of a fraudulent lien filed by a contractor who owed him money, and had decided it was easier to accuse than to pay. The case had been routed, through a process she did not understand at the time, to a judge who dismissed it on a procedural ground so thin that the paralegal handling the file had called the family afterward and said she was sorry, that she didn't know how that had happened. Arthur had lost the lien dispute. The contractor had never paid. Arthur had retired 5 years later with less than he should have had. Dominique had understood, by the time she finished law school, exactly how it had happened. She did not say any of this as she stood in front of Judge Calvin Mercer, with his hands cuffed behind him, and the indictment on the table, and the agents stationed at every door. She said it to no one. It was not the story of this moment. It was just the reason the moment mattered to her, in a way that no case summary could capture. She finished reading Mercer his rights. He said nothing. She stepped back. Fitch had already agreed to cooperate by 9:15. His attorney called Pemberton's cell before the agents had even finished processing him in the building, and Pemberton had given Dominique a look across the hallway that meant, "He's going to give us everything." He did. By 11 that morning, the forensic team had recovered 4,300 emails from the courthouse network that had been manually archived in a folder labeled Budget Reference, FY Archive, on a shared drive that technically nobody used. The emails documented, in some cases in embarrassingly explicit terms, The coordination between Fitch's office and the defense firm partnership, names of defendants, case numbers, anticipated assignment pools. One email sent at 11:40 on a Tuesday night read simply, "Confirmed 7C, your client should be comfortable." The email had been sent the night before a major civil rights discrimination case had been assigned to a judge who had dismissed 4 similar cases in the previous 2 years. That case had been settled for $60,000. The plaintiff had originally sought $400,000 in damages. The plaintiff was a 61-year-old black woman who had been denied housing in 3 consecutive applications at a building managed by a company with a documented history of discriminatory practices. Her name was not in the indictment. She was not a witness. She did not know this investigation had been running. She did not know that somewhere in the federal record, her case was now evidence. Dominique noted her case number in her personal files. She was going to make sure someone called her. The press had gathered outside the courthouse by 10:30, which meant someone had talked, which was fine. Dominique had expected it and had already coordinated the DOJ's communications office to issue a statement at 11. She watched the coverage briefly on her phone in the second-floor records room while Pemberton walked her through the preliminary asset report. The defense firm partnership had $6.2 million in traceable proceeds linked to the scheme. The offshore routing was simpler than she'd expected. A single layer through a bank in the Cayman Islands, back into a domestic account, registered to a consulting company that did not appear to have ever consulted on anything. The account had been frozen. Mercer's personal accounts, Dominique asked. Clean on the surface, Pemberton said. But there's a property in coastal Georgia, a 9-acre parcel purchased through an LLC that's 3 layers from anything with his name on it. The deed was recorded the same month the scheme apparently began. Dominique nodded. Get it. Already in the supplemental warrant. Dominique looked out the window for a moment. The Atlanta skyline was sharp and clear against the late morning sky, the kind of bright that hurt a little if you looked directly at it. Below the courthouse steps, she could see the reporters positioning themselves, the camera operators finding their angles, the whole machinery of public attention assembling itself around what had just happened inside this building. She felt the satisfaction of it. Quietly, precisely, without performance. Not joy, exactly. Something more austere than joy. The specific weight of knowing that a thing that had been wrong for a long time was no longer wrong in the particular way it had been wrong. That was the best you could ever honestly say about this work. You closed what you could close. You documented what you documented. You made sure the record was true. The full indictment named 11 individuals. Mercer, Holloway, Fitch, 4 attorneys from the defense firm partnership, 2 paralegals who had served as couriers, a judicial clerk who had worked at the assignment desk for 3 years, a private banker who had managed the offshore routing. They were processed that afternoon and transported to the federal holding facility. Mercer had managed to hold himself together in the courthouse, but by the time they were walking him to the transport van outside, something had let go. He looked smaller than he had at the conference room table. His robes were gone. He was in a grey suit that looked, suddenly, like any other grey suit, and the authority that had walked into that records room 3 days ago looking for a confrontation it could win was nowhere on his face. A reporter shouted a question at him from behind the cordon. Mercer looked toward the voice, and for a moment, Dominique thought he was going to say something. He opened his mouth. Then he closed it. He got in the van. Dominique gave her statement to the U.S. Attorney's press liaison at 1 in the afternoon, standing on the courthouse steps with the Atlanta sun at her back, and a small crowd of reporters and cameras in front of her. She was precise and she was brief, and she did not use the word justice once, because she had learned a long time ago that the word justice, spoken aloud in these moments, had a way of making people feel like the work was finished. It was never finished, she said. A federal investigation has resulted in the indictment of 11 individuals on charges of conspiracy, wire fraud, obstruction, and RICO violations, she said. The scheme involved the deliberate manipulation of case assignments in this district's civil rights docket over a period of approximately 6 years. She said, the full scope of the impact on affected cases is still being assessed, and the DOJ is committed to reviewing those outcomes. She answered 2 questions. She thanked the agents of the Atlanta field office and the forensic team. She stepped back from the microphone. Pemberton was waiting for her at the bottom of the steps. "The U.S. attorney wants a debrief at 3. I'll be there." Dominique picked up her briefcase. "Can you get me the contact information for the plaintiff in the FY 2019 housing discrimination case?" The 61-year-old. Case number 2019 CV04471. Pemberton typed a note into her phone. "I'll have it to you before the debrief." "Thank you." They walked together across the plaza toward the parking structure, the courthouse rising behind them, the cameras still running. The reporters already live on their phones, talking fast into the bright Atlanta day. The building had been standing for 40 years. A lot of people had walked in and out of it. A lot of decisions had been made inside it. Some of them fair, some of them legal, and some of them neither. That was what you inherited when you worked in systems as old and as complicated as this one. You did not get to choose a clean starting point. You started wherever you arrived, and you worked forward from there, and you made the record as true as you could make it. Dominique Reese had started in a lobby 9 months ago with a visitor badge and a briefcase and someone telling her she didn't belong in the building. She had belonged in the building. She had always belonged in the building. She walked to her car in the cool shade of the parking structure, unlocked it, set her briefcase in the passenger seat, and sat for a moment in the quiet before the 3 o'clock meeting, before the next case, before whatever came after this one. She let herself have the quiet, not long, just the length of a breath held and released. Then she started the car and pulled out into the light.